Namaste and welcome to a brief overview of share capital. We will go through this topic in four heads: capital and rights, premium and discount, issue of shares, and change in capital. Under capital and rights, we will start from section 43, share capital, get into voting rights. Then we will also deal with equity with differential rights, and section 48, variation of shareholder rights. Then we will deal with the two heads of securities premium account and shares issued at a discount. And our interest will take us to further issue of capital, sweat equity, bonus shares, employee stock options, and global deposit receipt. And to end with, we will go into alteration of capital, reduction of capital, buyback of shares, and cases where there is a prohibition on buyback. This is a overall view of our scheme of things. Let us get into the first part of share capital under section 43. Share capital of a company limited by shares. It says share means a share in the share capital of the company, and it includes stock. The share capital of a company limited by shares will be of two kinds: equity share capital and preference share capital. Equity share capital can be of two types: with voting rights and with differential rights. This is as to dividend, voting, or otherwise. Now we talked of it includes stocks. Stocks is a generic term. When you talk of a chunk of shares belonging to different companies, you refer to stocks, or shares of a company consolidated into different lots, that is called a stock, whereas shares refer to ownership of a specific company in specific lots of sizes and face values. If you go by the definition as given in the Act, equity share capital is one which is not preference share capital. That forces us to see what is preference share capital defined as. Preference share capital is one which has preferential right as to two things: as to dividend, which can be a fixed amount or it can be calculated at a fixed rate. And so far as the repayment of capital is concerned, there is a preferential right, and it may have a preferential right for payment of any fixed premium specified in the memorandum or articles. A share which carries preference in terms of dividend and repayment of capital is preference capital. If we go further, share capital divided into two, equity and capital. Equity can be with voting or differential voting. Preference has got essentially one privilege with it: preference as to dividend and preference as to repayment. There is also a provision which says in addition to this, they might have a right to participate with equity holders in dividend and also in surplus on winding up. Just to see the specifics. Capital which shall be deemed to be preference capital, it is entitled to either or both. In addition to preferential rights as to dividend, it has a right to participate, whether fully or to a limited extent, along with the share capital in repayment on winding up. It has a right to participate in any surplus which may remain after the entire capital has been repaid. Now, this is what we are referring to. Now, this is the overall scheme of equity capital, preference capital, mandatory preferential rights, and possibility of an additional right along with the equity holders to share with the dividend at the end and also to have a share in the surplus. That is up to the share capital under section 43. Now we will go to voting rights under section 47. Equity shareholders have got a right to vote on every resolution placed before a company, and the voting right of an equity shareholder on a poll shall be in proportion to the paid up equity capital that he has. And a preference shareholder, he will have voting right to touch only those resolutions which directly affect his rights. If something doesn't affect his rights directly, he doesn't have voting right on that resolution. Means voting is used to protect your rights, be it in the normal course or on winding up. Therefore, the resolutions which interest a preference shareholder are three. One which directly affects his rights. Second, on any resolution on winding up because it affects his rights. And on any resolution which involves repayment or reduction of other parties, including equity shareholders and preference shareholders. Because when the money of the company is used to repay other creditors or other parties, that affects the rights of a preference shareholder, and hence he also has got a right to vote on resolutions which involve repayment or reduction. Once again, his voting right will be in proportion to the paid up amount vis-a-vis the paid up preference share capital of the company. Now, this is regarding what a member as an equity holder has got a right to vote on every resolution, and preference shareholder has got a right to vote on resolutions which affect his rights. And there is a special case where dividend in respect of, say, preference shares or a class of it has not been paid for 2 years or more. That preference shareholder will have a right to vote on all resolutions placed before the meeting. Means his rights are affected deeply. Therefore, to protect that, he is entrusted with the powers to vote on all resolutions placed before the company. This is a special situation where the preference shareholder gets a right to vote on all resolutions. Once again, the number of votes or the value of votes depends upon, once again, the proportion of paid up capital on those shares vis-a-vis the total paid up capital of their class. It may be equity shares or it may be preference shares. And between equity and preference, once again, the ratio is paid up capital of equity versus paid up capital of preference. Just to take an example, if 10 lakh rupees is the paid up capital of preference and 100 lakhs is the paid up capital of equity, then the ratio of votes will be preference 10, equity will be 100. That is how the votes will be cast. That takes us to the equity with the differential rights, DVRs, differential voting rights, under Rule 4 of the company's Share Capital and Debentures Rules 2014. Let's look at it. Differential rights as to dividend, voting or otherwise, generally known as the DVR shares. Now, to issue an equity share with a differential right, there are certain essentials. Essentials are as to the articles has to provide for it. The issue has to be authorized by an ordinary resolution. And in case of a listed company, the requirement goes to that of postal ballot resolution. And when you issue those shares, the voting power of those who have voting rights, which are differential, should not exceed 74% of the total voting power. Because every share has got a voting power, and a share may be with differential voting or without voting power at all. Now, when the differential voting power held by a share, if you consider only differential voting shares, their volume should not exceed more than 74% of the total voting power. And since this is a special type of shares which is being issued, this is a privilege. Not every company can issue it, and therefore what is insisted upon is when you issue an equity share with only dividend right and no voting rights, it becomes some sort of a share with dividend as an assured income. To assure that income, it has to be seen that the company which issues a DVR has to have a track record of consistent profits for the last 3 years. This is the compliance requirement in respect of the DVRs. Let's go ahead with it. When a company wants to issue these shares, we have seen it should have consistent profit record, and there is the requirement coming here. It says they should not have defaulted in filing financial statements and annual returns for last 3 financial years. And there should be no default on declared dividend payments, no default on repayment of matured deposits, and anything which is due for redemption in preference or debentures, it should have been paid on time, and all payment of interest on such deposits and debentures or dividend should have been timely done. We are talking of financial discipline in terms of payment of dividend, repayment of debentures, preference shares, and repayment of deposits and interest thereon. And once again, this is regarding the subsisting default in payment. And it also says the company has not defaulted in payment of dividend on preference shares or any term loan taken from a public financial institution or bank or interest payable thereon or any PF, ESI, certain statutory payments. There should be absolutely no default, and sometimes the amount of unclaimed dividend has to be transferred to Investor Education and Protection Fund. All these payments should have been done by the company without any default. These qualifications are essential to ensure that the company which issues shares with the differential rights has got firm discipline and financial strength to meet its commitments on time, both in the past and in future, and there are no statutory defaults or term loan defaults. And if at all a default is there under any of these heads, under EFG, what the rules state is these could be waived only after expiry of 5 years. For example, if a company defaults in the year 2006 till 2010 and it cannot issue differential rights as to dividend because we have to await expiry of 5 years from the last default. And once 5 years are a clean period, then we can proceed to issue equity shares with differential rights. And there is one more requirement in respect of the company, that the company should not have been penalized by the court or tribunal for the last 3 years under any of these acts of SEBI, Securities Contract Act or FEMA, and there must be no punishment on the court in terms of penalty for offenses. In the sense, what the act states is equity with differential rights can be issued by only companies which are quite disciplined and which have sound financials, and that is where this repayment discipline and penalizing by the court or tribunal is resuming importance. Just to have a look at the thing, article should provide resolution has to be there, or it should be through a postal ballot. It cannot exceed 74% of the total voting power. Distributable profit should be there for 3 years in terms of its filing, payment, repayment, and court penalty. It should be a clean company before it issues a differential rights shares. And when we say we need a resolution to be passed or a postal ballot to be passed, any passing of resolution has to be preceded by a notice to be sent to shareholders. And this is where the Act very clearly says if you are sending a notice to the shareholders as an explanatory statement to the notice under section 102 or under section 110 explanatory statement to the postal ballot thing, it should contain specific details about the entire scheme of things. The explanatory statement has to say what is the total shares, what are the differential rights, what is the percentage of shares with differential rights to total post issue, reasons for issuing the shares, at what price, what is the basis. This is to have more of transparency than anything else. And if it is in case of a private placement of the same thing or preferential issue of the shares, the explanatory statement should state how many number of shares have been allotted to promoters or directors or key managerial personnel, and what is the balance shares given to persons other than promoters, and what is their relationship with any of the promoter groups. And in case of public issue, what are the different classes of applicants, including promoters, directors, and key managerial personnel. The whole idea is here to ensure that the differential vote right shares are clearly identified as to the holders so that it becomes more transparent and more visible in terms of who is concentrating voting power of the company. This has to be within the knowledge of the shareholders when they receive the notice with explanatory statement or explanatory statement for the postal ballot. And once again, the requirement continues in terms of the percentage of voting rights carried by the differential voting shares, how the terms vary between one with the differential voting right, one without differential voting rights, and with the issue of this size, what is the impact on the control and management of the company. And once you issue these shares, the earning per share will vary. What is the diluted earning per share? And after the issue, which is proposed to be done under the proposal, what will be the new shareholding pattern? How does it differ from the existing shareholding pattern? Means the explanatory statement has to explain very clearly the process of issue of these shares, and it should also deal with what is going to be the consequence in terms of the control of the company and in terms of the earnings per share and the shareholding pattern. And an explanatory statement with these details will keep us fully posted on the composition of the shares, its concentration in different groups, and then what is its consequence, composition, consequence, and also the numerical particulars of the entire proposal. And we also have other requirements. See, when you send a explanatory statement, it should also be reflected in the director's report for the year. Same details will appear in the director's report. If we can be specific, what are the total shares, details of differential rights, percentage of differential rights, price at which it is issued, shares issued to promoters, change in the control, diluted earnings, pre and post issue shareholding pattern. These are all appearing in the explanatory statement. Whatever is indicated to the shareholders, it should also form a part of the board of directors report for the financial year as a proceeding. And it also states there are a few additional requirements. This process of issuing differential rights is a new portion of shares. It cannot involve existing rights to be converted into shares carrying differential voting rights. It has to be a new bunch of shares issued by the company. It cannot be taken to empower the existing shareholding. It has to remain as it is. And in case of differential shareholders who might not have voting right, but they will have other rights like bonus and right shares on par with the other equity holders, means the differentiation is largely as to dividend and voting. Means what? Dividend may be slightly higher than normal and voting may be nil. They might not have any voting powers in the meetings. And the register of members shall contain particulars equally for both, for shareholders with the differential rights and shareholders with normal or additional rights. Now this is as to the requirements of the board report contents and the other essential requirements as to you can't convert an existing share, and the shareholders of differential voting will be eligible for all other facilities except for variation in dividend and voting, and register of members will record things on same pattern as the normal shareholding people. Share capital, voting rights, equity with differential rights, and that takes us to variation of shareholders' right. Can the shareholders' rights be varied? Variation could be done. The rights attached to shareholders of any class may be varied. But once again, it is a matter of special resolution. It has to be consented by not less than 3/4 of the class of shares by means of a special resolution. Not less than 3/4 means when the votes are cast against the resolution, number of votes in favor should be 3 times or more than the number of votes cast against it. 3:1. That is 75%. And for variation of shareholder rights, first we should see that there is an enabling provision in the memorandum or articles. And if there are many class of shares and we are varying one particular class, say A, and this is remotely connected with a class called C, we are taking consent of class A and altering their rights. But if it is connected with another class of shares and its rights are also affected, then it is also required that we should get their consent with a voting of not less than 3/4 of the holders of it. In the sense, any variation, directly or indirectly, if it is done by the company, even when it is provided by memorandum or articles, a special resolution with 75% consent of votes cast has to be there in case of one company which is directly affected, one group, and other groups of shareholders who may be remotely affected by this, they also should consent to make the resolution or make the change valid. Then, even after this resolution is passed, if some shareholders say we don't want to accept this, and if their number is not less than 10%, there are two requirements. One, they should not have voted in favor of the resolution. Number two, their size has to be not less than 10% of the group of that particular shareholders. They can move the tribunal to have the variation cancelled, and that movement application has to be made within 21 days. Once the resolution is passed here, people who have not voted, if they constitute, or people who have voted against, if they constitute not less than 10% of the voting power of that class, they can approach the tribunal, company law tribunal, and that application has to be put within 21 days. And where such application is made, even when the resolution is passed, it is kept in abeyance. It will not be implemented until the decision of the tribunal is made. We have to await the decision of the tribunal after hearing. And the decision, when made, will be binding on all the shareholders. And once the decision of the tribunal is come, the company will file it with the ROC, a copy of the order, and take it on record within 30 days. And in respect of variation of shareholders' right, company has got a major responsibility, and therefore it has to ensure that there is no default, because if there is a default, company and its officer will have penalties and criminal punishments involved, and that is the reason. And even besides that, company has to follow the procedure and carry out the due process of law. This is the provision regarding the consent of 3/4, passing the resolution as a special resolution, and if it affects other consent of other class, we have to obtain it. If someone is not agreeing with the contents, then he can move the tribunal. We have to await tribunal's decision till such time the resolution will not have any effect. Once the decision comes, it is binding on all shareholders, and the company will file with ROC within 30 days. Company has to take care that is perfect compliance, so that it doesn't affect or it doesn't attract the penal provisions of the Act both as a company and for the defaulting officer. With that, we will have covered share capital and its meaning, voting rights, equity with the differential voting rights, and variation of shareholders' rights. Now let us come into premium and discount. A company receives share premium when the shares are issued or allotted at a premium. Now we have to understand as to how this premium which is received by the company could be used. Application of premium received on issue of shares. Section 52 talks about this, where a company issues shares at a premium. The amount of premium as received shall be transferred to a securities premium account or share premium account. This is so far as the nomenclature of the account where the share premium is parked in the financial accounts. Then, where we can use it? The section says you can use share premium account for specific purposes. You can use it for issuing fully paid bonus shares. If you have got in your balance sheet preliminary expenses carried forward, you can use this to write off and set off one against the other. If there are expenses which you have incurred in issuing shares and debentures, those expenses can be set off against the share premium account. And you might have redeemable preference shares which you will be redeeming. When you redeem a preference shares, you might be paying premium. You can use this premium to pay the premium on redemption. And share premium can also be used to purchase own shares, which we call as buyback. Buyback of shares under section 68. Share premium could be used for these purposes and these purposes only. 5 purposes: issue bonus shares, write off preliminary expenses, write off issue expenses of debentures and shares, or use it for premium of redeemable preference shares, or you can use it to buy shares of one's own company, which is called buyback. In addition to that, if you don't use it for these purposes and use it somewhere else, then it amounts to reduction of capital. Now you will ask us as to what is great about it. Reduction of share capital is not permitted in the normal course. It is a deviation. Therefore, if it amounts to reduction of capital, company has to ensure that has it followed the procedure to be adopted as prescribed in the Act for reduction of capital. Else, it will be an offense by the company. Now, this is in brief about how share premium. Now let's have a look at the shares issued at a discount. Let's have a look at it. There is a bar on a company on issuing shares at a discount, with an exception. A company shall not issue shares at a discount, means it has to be issued at par or at a premium. However, if the company is issuing sweat equity shares, it is allowed to issue the shares at a discount. We will be seeing separately what is this sweat equity share. And what if a company proceeds and issues shares at a discount? The transaction will be void and any money received by the company has to be refunded with an interest of 12% per annum from the date of issue of such shares. Means the decision of issue doesn't stand the test of law and it has to be refunded and the transaction is void. It doesn't exist. However, sometimes a company in difficulties enters into an arrangement with the creditors, or there may be a restructuring done by financial institutions or banks under the Reserve Bank India Act. As a part of the scheme of restructuring, it is allowed for a company to issue shares at a discount because it is a matter of accommodation by the creditors. Therefore, this is a special instance where the company can issue shares at a discount. To revisit the whole thing, there is a penalty because anything against this section is an offense and every officer in default shall be, and the penalty is quantified. We have to be more worried about ensuring compliance, being at the same time aware of the penalty which is attracted. To put it once again, issue not allowed except when it is sweat equity shares. Any transaction which is done is void. When you make a composition with the creditors or there is a scheme of restructuring done by the banks, it is allowed. If you don't follow the rules as specified in section 53, you will be attracting penalty. Now that is about the share premium account and issue of shares at a discount. Now let us come to the third aspect of this topic as to further issue of capital. A company is already running with the equity shareholders and existing structure. It wants to issue new set of shares that will be covered under fresh issue of capital. Let us understand the further issue of share capital. If we look at it, section 62 says when you make a fresh issue of shares, you have an option to offer such shares to three entities. First one is you can offer it to persons who are holders of equity shares of the company as on the date of offer, or you can issue to employees under a scheme of employee stock option, which is separately authorized under a special resolution, or you can offer it to any person under a prospectus which is authorized by a special resolution. Therefore, further issue could be to three entities, 1, 2 and 3. The other two we will be seeing employee stock option separately, and anything which is issued to outsiders by way of a special resolution after sticking to the requirements of issue of prospectus under chapter 3, it is also respected. But the first part of it, which is to people who are holders of equity as on date, the Act prescribes a procedure for that. It says the company should make a letter of offer, and the letter of offer should be sent to the existing shareholders, and they should be given 15 days time to either accept the offer or decline the offer. How do you reach these letters of offer to these people? It could be sent by electronic mode, by registered post, or by speed post, but ensure that you get an acknowledgement, and it has to reach them at least 3 days before the issue opens, and once issue opens they have got 15 days. And this is called a rights offer. This offer will also be accompanied by a renouncement part of it. The existing shareholder can accept the shares fully. He can reject the shares fully, or he can accept partially and renounce partially in favor of a third person. The party who is an outsider, he can take the renouncement application and he can apply to the company, making payment as per the terms. And this renouncement can be either full or partial. For example, if the party receives an offer for 100, he can accept full 100, or he can renounce full 100, or he can accept 10 and he can renounce 90. And that renouncement application has to be filed within the specific date of offer. If the shareholder declines, the ball gets into the court of the board. Board can dispose of those shares in a way it considers in the interest of both shareholders and the company. Means, to go by the wording of the act, it should not be disadvantageous to both shareholder as well as the company. This is how the first set of offer will be dealt with. Second set is pertaining to the offer made to employee stock option. Third one is an offer which could be made under a regular prospectus for cash or for consideration other than cash, complying with the requirement of Chapter 3. And sometimes these rights issue, it says you cannot issue shares to others, but there is an exception. A company must have taken a loan or issued debentures. When it takes a loan or takes a debenture, there might be a clause in that debenture or the loan that in the event of non-payment or in terms of this issue, these debentures or loan will be converted into equity. This is an agreement which is already done. When that loan was taken, when that debenture was issued, there must have been passed a special resolution by the company consenting that we have no issue in granting additional shares to these people when we convert the debentures into shares or loan into shares. Therefore, the rule that further issue should be to only shareholders, not anyone else, has got an exception in this. This is increase of subscribed capital caused by exercise of an option by a term attached to debentures or loan which were approved in the past. And any rule that is there, any privilege that is there, it is always subject to any extra steps taken by the government. Notwithstanding what is stated in this section on further issue of capital, it is up to the government in public interest to direct that some loans or debentures be converted into shares, and they should be accordingly documented with the company, including changing the respective sources of power like memorandum and articles which empower the company to issue the same. This is an exceptional case of government intervention in public interest. For example, if the government has given a loan to the company and the company has defaulted, there was no clause in the original issue that it can be converted into equity. Government can step in, and as a part of public interest and protecting the interest of existing shareholders and the company, it can state that we can convert that and add it to the existing shares, and further issue of shares could be done. And when such things are done by the government, once again, any decision which affects your right, you have got a remedy, and you can always approach the tribunal from the company against the decision of the court, decision of the government, and await their decision after hearing the company and the government. And whenever the government converts existing loan or debentures into equity, it will have taking care of the financial position while deciding on what should be the term of conversion and what should be the rate of interest payable on the debentures or loan and other terms as it considers necessary. And as we said, if the company moves the tribunal against the order of the government and if the appeal has been dismissed, then company is bound to implement the decision of the government to issue further shares in conversion, and automatically the share capital in various documents of the company stand increased to the extent of the new issue approved by the state government. Suffice to say, this whole issue talks of further issue of share capital can be done to only existing shareholders, absolutely no right, no problem. But the point is, if there is an existing debenture or loan raised with a condition of conversion, that prevails. Second, government also can step in and order for conversion of certain loans or assistance given to the company on terms it finds essential, keeping in mind the financial status of the company. The company has got the right to move the tribunal as an appeal. If the appeal is dismissed by the court, company has got the duty to implement the decision of the government, including changing the articles and giving effect to the transaction in all its aspects. That is regarding the further issue of capital. This brings us to a topic called sweat equity. Sweat equity was an issue of interest in case of IPL also. I think it was in 2010, Kochi Tuskers had payment of consideration to one of the parties as sweat equity, but it did not conform to the norms and therefore the whole scandal broke out. That is history. Let us get into sweat equity as a part of it. What is sweat equity? In section 53, we said any further issue of capital has to be for the existing shareholders. But section 54 gives an exception. It says, notwithstanding anything contained in section 53, means this is an exception to section 53. A company can issue sweat equity shares of a class of shares already issued. Class of shares is already there, but it has to follow three conditions. It should be by a special resolution of the company. Number one, it should specify the number of shares, what is the consideration for which it is issued, and it can be issued to two sets of people. The people who receive sweat equity has to be either directors or employees. And where the shares are listed, the issue has to be based on SEBI regulations. Three specific requirements of sweat equity: pass a special resolution, put all details of what is the number of shares, what is the consideration, and ensure it is issued to either a director or an employee. And who is the director employee, we will see. Third, if it is listed, it should be as per SEBI regulations. Okay. Then such equity shares to its directors or employees, and we saw in case of shares to be issued as discount, it said accepting sweat equity shares. Sweat equity shares could be issued at a discount, means they can be sold at a price lower than their face value for consideration other than cash also. Company need not have to receive cash. Why it is given? It may be given for the know-how. Company gets technical know-how, or it might get intellectual property rights, or some value addition somewhere. This is what the company receives as consideration other than cash. They might not be paying you in cash, but they will give you the technical know-how, or they will give you the intellectual property rights, or they may give you some value addition in a process or product or marketing. Who is an employee? We said it should be an employee or director. Employee must be a permanent employee on the regular roles of the company. And who is a director? Is a director of the company, and he can be a director of a subsidiary also, or he can be a director of a holding company also, but he cannot be a nominee director, or he cannot be an independent director. That we have to indicate. And we came out a word called value additions here. Value additions means actual or anticipated economic benefits, some value saving somewhere company receives, or professional for providing technical know-how. And we have to see one thing. An employee is normally paid salary for what he does. But if he has done something which is different from what he is supposed to do in his employment, his salary doesn't cover that. If an employee provides technical know-how, if an employee provides IPR, or if an employee provides value addition besides his normal job, it is not covered by his regular remuneration. It is not included in his regular remuneration. Therefore, he gets his salary, in addition to that, he will receive sweat equity shares. Sweat equity shares have nothing to do with the normal course of work. Sweat equity shares are more concerned with these three things: technical know-how, intellectual property rights, and value additions. Let's go further. And the rights, limitations, restrictions applicable to equity shares equally apply to sweat equity shares. Just because they are given for consideration other than cash, their rights are not affected. If there are existing equity shareholders, we have issued a fresh equity shares as sweat equity shares, they are equal in all respects, ignoring that they have not been issued against cash. Their rights are the same and they rank pari passu. In the sense, if they are in existence for 365 days in a year, they are entitled to all rights which the other class enjoys as equity shareholders. If they are for say 6 months in a year, they will get benefits for 6 months. The rest of the equity will get benefits for 12 months. Just to revisit, it is an exception to section 53. It should be a special resolution. Details should be indicated in terms of consideration and value received. It can be directors or employees. SEBI guidelines to be followed by listed company. It can be for consideration other than cash. It can be for technical know-how or intellectual property rights or value additions. Employee should be a permanent employee. He can be an employee of a subsidiary or holding company of the group. And the value additions are nothing but economic benefits. They are not included in the normal remuneration paid to an employee. So when you issue sweat equity shares, once again, you need to have a special resolution and you will make an explanatory statement. And as we have seen, when you make an explanatory statement, you make a project features list. Which board meeting did discuss this? What was the justification for the issue? What class of shares are issued? Total number of shares? Classes of directors or employees covered? What are the terms and conditions? What is the time period of association of such person with the company? Is he a new employee or how long he has been there? What is his contribution? What is the relationship with the promoters? At what price the shares are issued? What is the consideration? And does it affect the remuneration of managerial, ceiling on managerial remuneration as per the Companies Act? And is it in line with the accounting standards, the way we have treated in the statement of account? And what is its impact on the earning per share once these shares are issued. Means what? When you issue this explanatory statement, your whole idea is to tell the equity holders this is how your rights will be affected by issue of these shares. How many shares are issued, in what way they are issued, what is the value, how many numbers, to whom, his background, and what is the impact on EPS, how it will be presented as per the accounting standards. Now this is the summary where the explanatory statement has to appear like. As we have seen, this has to be reflected in terms of certain other additional conditions also. Once you pass a special resolution, it should be implemented within next 12 months. It expires at the end of 12 months. And there is a restriction. A company cannot issue sweat equity shares in an year more than either rupees 5 crores or 15% of existing paid up capital, whichever is high. This is the outer limit for that. And at any point in time, if you take the balance sheet of a company, sweat equity shares in the total capital means shares which are issued for consideration other than cash under this section, they should not be crossing the limit of 25% at any time. These are the two conditions to be ensured. And when you issue shares for consideration other than cash as a sweat equity, there is a lock-in. They can't be sold within next 3 years. And just like a quarantine stamp, the share certificates will be stamped in bold, stating they are locked in. And in records, there will be the record as to at what price the shares are issued, because they are not issued at the regular price. There will be a price for the shares issue based on a registered valuation. Secondly, whatever benefit they have bought, we will be paying for it, and what they have brought has to be valued by a registered valuer. To put it very clearly, there are two things. One, A, there is a technical know-how. What is its value? Its value may be 1 crore. B, we are issuing him shares. What is the price of the shares? Price of the shares normal is 100, but we are giving him at the rate of 80. When you are giving it at 80, two things become very clear. Shares are valued at a price determined by the valuer. Our shares are valued at 80. Second, the property value is valued at 1 crore. This is once again based on the registered valuer. Both should be valued. And then we derive the number of shares. 1 crore divided by rupees 80 is the number of shares to be issued. That is the extent of sweat equity. And a gist of the critical elements of the valuation report which is there also should go along with the explanatory statement. And as we saw, the board of directors report for the year should once again present this summary. It should say during the year we have issued sweat equity shares with the following features, which is nothing but an extract from the explanatory statement which was sent. Therefore, these two documents are mirrors of each other, issued at different points in time. Therefore, for a sweat equity share, besides the explanatory statement, we have got the limitation in terms of it should not exceed 15% of the paid up capital or rupees 5 crore during a year, and at any point in time it should not exceed 25% of the total capital. There is a lock-in, and there should be a registered valuation both for the shares and for the property received, and board of directors report should mention clearly with same particulars on the transaction of sweat equity shares. That brings us to bonus shares. Under section 63, we have seen share premium could be used for issue of bonus shares. What are the conditions under bonus shares? A company can issue bonus shares by making use of its reserves. Reserves means profits of the past carried forward, It can use the share premium received, and companies have got a practice of creating a capital redemption reserve out of their profits on a regular basis. These three put together could be used for issuing bonus shares to the shareholders. Bonus shares conveys shares issued without any charge to shareholder. He need not have to pay for it. Now, there is one more reserve which normally appears in the balance sheet. People maybe revalue their fixed assets, land, building and others, and show it the corresponding revaluation as an additional reserve on the liability side, which is called revaluation reserve on revaluation of assets. This is a book entry just to reflect reality. This cannot be distributed to shareholders. Therefore, bonus issue cannot make use of any revaluation reserve. Therefore, these three components could be used for rewarding the shareholders with a bonus issue. And bonus issue means what? It converts share premium, capital redemption and free reserves into bonus shares, into share capital, which is nothing but capitalization of profits. Now, to capitalize a profit in a company, there are some conditions to be fulfilled. One, it should be permitted by the articles. Articles should say company is authorized to convert reserves into capital. Second, it should be discussed in the board. There should be a board recommendation. Third, when you convert these things into capital, they become shares. Shares will get rights and dividends. It will affect the rights of other stakeholders. In that case, one has to ensure that there is no default in the payment of interest or principal in respect of deposits and debts. Once again, clean, strong financial companies alone are permitted to go for bonus shares. If you are not servicing your existing creditors or existing stakeholders, you cannot reward your equity holders by converting that into capital, because when you convert or capitalize, your commitment of dividend increases, outflow of dividends in future increases, earning per share comes down because the number of shares gets bloated. And the company should have not defaulted on any statutory dues. And before you issue bonus shares could be issued only on fully paid shares. Therefore, if the existing shares are partly paid, first they should be fully paid up. Only fully paid up shares are eligible for bonus. This has to be done as a part of preparation. And there may be other conditions as may be prescribed by SEBI or stock exchanges which needs to be fulfilled. And when a company issues bonus shares, it cannot be bartered for dividend. Company cannot tell the shareholders, this year we will give you bonus, but we will not give you dividend. It is prohibited. There cannot be a barter between bonus shares and dividend. Dividend is independent of bonus shares, and therefore bonus cannot be issued in lieu of dividend. And second, it is just like dividend. Dividend once declared cannot be cancelled. It has to be paid. Similarly, bonus once declared cannot be withdrawn. Company has to issue the bonus shares. Once announced, shall not be withdrawn. Bonus shares are a simple thing. You capitalize the profits. You capitalize these three things. You cannot capitalize revaluation assets, but you should be a clean company. Article should permit, board should recommend. There should be no default in terms of deposits and debt securities. No defaults of statutory dues. Shares should be fully paid up. And there may be any other conditions. You cannot barter bonus for dividend. And once announced, it is just like a debt. It has to be issued by the company. And the company cannot announce once and then say withdrawn. No, there is no option to withdraw. That brings us to the employee stock option. Companies are issuing option to buy shares in the company at a concessional price. We have seen Sweat equity is issued at a price lower than the normal, and even the stock option to employees is issued at a price lower than the normal. It is priced based on the valuation. The whole logic behind employee stock option is to motivate the staff and to retain staff, reduce staff turnover. This is covered under Rule 12 of the Rules of 2014. Let's have a look at it. A company can issue shares as employee stock options approved by shareholders. Once again, because when you issue additional shares, the shareholders existing will be affected. Therefore, they should pass a special resolution. To which employee? He has to be a permanent employee. He could be a director, but he cannot be an independent director. And he could be an employee of a subsidiary. Whatever we used in sweat equity, it could be used here also. He could be an employee of a holding company also. But he should not be related to the promoter group. Even director, he should not be related to the promoters group. Or he should not be related to one who holds more than 10% of equity shares of the company. Employee stock option is to employees or directors. Approved by shareholders, permanent employees, directors, and not related to promoter group. What will you do? Once again, when you issue under a special resolution, when in doubt, ensure you disclose in an explanatory statement number of stocks, classes of employees, what is the appraisal process in deciding the value. The shares are to be valued before it is given. The scheme has to be assessed. Now, there will be three stages. There is a stage of granting. There is a stage of vesting. And there is a stage of exercise. What happens is, as per the agreement, an employee will be granted the shares at completion of an X amount of service. That is the stage of granting. He has got an option to buy the shares of the company. But that grant becomes his right to exercise after a specific period. And that duration is called the vesting period. Once it vests in him, it becomes his personal right to buy those shares. Grant vests. Once it vests in him, when it becomes his right, he can exercise his right to buy and he can take his time. And that period is called exercising period. Means the share moves from grant to vest to exercise. Till it vests in him, the right has not yet crystallized. Once it vests in him, it is crystallized with him, it cannot be withdrawn, he can exercise. If he doesn't exercise, there are details to be looked into. We will just have a look at it. The requirements of vesting and the period of vesting has to be specified. Period of vesting. What is the time required from grant to vest has to be decided. It should be a part of explanatory statement. Maximum period within which it has to be exercised, vested. And when he buys, what is the price at which he should be paying the company? And what is the formula based on which it is arrived? And what is the process of exercise when he buys his shares from the company? And after he buys, what is the lock-in period? An employee cannot just buy the shares and then offload in the market, because there will be a difference between the price. What you get as an employee is far different from what is prevailing in the market. But the company says, or the explanatory statement should state what is the formula for exercise price, what is the process of exercise, and then what is the lock-in period. This detail has to be indicated in the explanatory statement. And it should also state the maximum number of options to be granted to an employee and how the options have been valued, what are the conditions for vesting, and when it can lapse in case of termination of employment, his right to exercise the option of buying shares. The specified time period within which the employee shall exercise the vested options in the event of a proposed termination or resignation of the employee. And the entire scheme has to follow the applicable accounting standards for presentation and accounting. Revisit. The explanatory statement talks of the details of the scheme, the process, period of vesting, maximum period for vesting, exercise of price or formula which is used, and what is the lock-in period, what is the maximum period allowed for options, number of options, method used to value, conditions of vesting, and what is the maximum period available for exercising, what happens when the person is terminated, and what is about the compliance with the accounting standards. These are to be available in the explanatory statement. And to take some more conditions of it, the companies granting option to its employees will have the freedom to determine the exercise price. And it should be the exercise price which is decided by a formula has to be as per the accounting policy. Special approval of the shareholders is required when the employee belongs to a subsidiary or holding company, and special approval is also required when identified employees during any 1 year will be offered more than 1% of issued capital of the company. If an identified employee gets more than 1% of the issued capital, it has to be brought to the notice of shareholders and it should be specifically approved. The company may by special resolution once again can vary the stock option terms, provided it is not exercised. Till the employee doesn't exercise, the terms could be varied by the company. But it should not be prejudicial to the interest of the option holder. Maybe it is for the sake of operational convenience. And such variation has to be with a notice for passing of resolution of variation. It should disclose the full variations and why we are varying the terms and who are the beneficiaries of such variation. Means to issue the employee stock, you have to pass a special resolution, and even to vary the terms could be varied before an employee exercises his right, and the variation should not result in prejudice to the employee. Once again, it has to be passed by the employees by a special resolution, and that resolution should once again disclose what is the rationale behind the variation part of it. And we said between vesting and grant, there should be a minimum of 1 year. You are eligible and it vests after 1 year. Company can specify the lock-in period. Till the exercise is done and shares are acquired, there is no right to get dividend, because the only when shares are acquired, they are issued by the company for the price received, and dividend and vote will come only subsequently. This is just clarifying as to what are the rights accruing holder. Just to repeat, company has got the right to freedom to fix the price. Terms of option could be changed by special resolution with proper disclosure, but should not be prejudicial to the shareholder. And whenever the shares are issued to employee of a subsidiary, or whenever shares are issued more than 1% of the paid issued capital of the company, special approval of the shareholders is required. There should be a minimum of 1 year between grant and vesting. Company can specify the lock-in period, and till the shares are exercised and bought by the shareholder, he cannot have the right to dividend or vote. And the amount, if any, payable by the employee, if he has paid something and if he has delayed exercising beyond a specific period, the company can refund the amount if he crosses a specific period, or it can forfeit the amount depending on the situation. This is a penalty for not exercising the option within a specific period, which was one of the terms of sanction. And an employee, once he is given an option, he cannot transfer it, he cannot pledge it, he cannot alienate or encumber it in any way, or he cannot mortgage it also. It has to be by the employee or his legal representative. In the event of death, his legal heirs could use the right to exercise in respect of vested shares. In the event of resignation, he can exercise what is vested, but granted into vested into exercise. If it is not vested, it will expire. Therefore, it is granted. After 1 year it vests, it becomes his property, but he has to buy it. Only then the share becomes his. If he fails to buy it, and if he resigns or he expires, the validity of the shares will expire and he loses in the event of resignation on termination. Therefore, once a share vests, better to wait for the right period and then exercise and acquire the shares when the company allots the shares to the people. We have just seen here now, failure to exercise, amount paid could be forfeited or refunded. Legal heirs, it cannot be transferred or pledged. Legal heirs can access it in the event of death or total incapacity, and in the event of resignation or termination of employment, shares not vested will expire. Shares vested can be converted into exercise and shares could be bought. As we said, whatever comes in the explanatory report, it has to be in the director's report also. Explanatory statement has to be summarized here, and director's report for the year will say how much option was granted, how much vested, how much exercised, how much options lapsed, what is the price that we realized, what is the number of shares issued. Is there any variation in terms which was done? How much money was realized by the company? And how many options are still in force? Employee-wise details. And the grouping of up to 5% and grouping of 1% of the issued capital, the select few which is there. The company shall maintain a register of employee stock options with the particulars of options granted, and it will be maintained at the registered office of the company. The entries in the register will be authenticated by the company secretary, and the SEBI regulations are to be followed if the company is a listed company. This is regarding the Board of Directors report and the employee stock options register, authentication, following of SEBI guidelines, and details of variation of terms if any, and employee-wise details of people belonging to the two groups of 5% and 1%. This brings us to another aspect which is known as global deposit receipts. It is issued within the country, but the GDRs are listed outside the country. This graphic presentation must help us understand the situation better. Now we have the overseas depository. Overseas depository has got a depository agreement with the Indian company, and overseas depository also have an agreement, custodian agreement, with a domestic custodian. This domestic custodian holds shares on behalf of overseas depository. It so happens overseas depository buys shares from the Indian company. When he buys shares from the Indian company, he remits through the overseas bank the money to Indian bank belonging to the Indian company, which will issue the shares. The shares will be issued and it will be kept by the domestic custodian on behalf of overseas depository. On the strength of this, overseas depository will issue GDRs to the local investors. Therefore, the overseas investors have got link only with the overseas depository, and the Indian company has got link only with the overseas depository. In the register of members of the Indian company, there will be only overseas depository which will be shown as holder of shares. Therefore, the voting rights and the dividend will move only to the overseas depository. If the overseas investor wants to be in the register of members of the company, then it has to be after the shares are transferred from overseas depository to the overseas investors, and there is a direct link with the Indian company. But so far as the GDRs are concerned, the direct link will be only between these two entities. This is the brief explanation for the way the things flow. Just to see, eligibility should be under FEMA. It is issued by the overseas depository bank. RBI guidelines are to be complied with. The board of directors have to pass a resolution. Special resolution of shareholders is required for the purpose of issuing the GDR, and a compliance report is required to be prepared by a professional merchant banker. How does it work? The depository receipts are issued by way of public offering or private placement against the issue of new shares in accordance with the conditions of RBI. The shares will be allotted in the name of the overseas depository bank. Indian company will issue the shares to the overseas bank, and the overseas bank will issue depository receipts from its end. Therefore, in India, the company issues; outside the country, the depository bank will issue the amounts. The depository receipts will be issued in the name of the overseas bank, and therefore it will be appearing in all the registers as a shareholder. And the person who have bought these GDRs outside the country, they will enter the register of members only when they convert GDRs into shares and become members of the company. Then only they will be directly becoming the members of the company and enter the register of members. Proceeds of the issue has to come from the overseas bank into Indian bank by way of remittance. And this depository receipts issue will not be attracting the public issue regulations nor the prospectus, and the register of members will not enter the names of buyers outside. It will be in the name of the depository bank in the register of members. This is so far as non-applicability of certain provisions of the Act are concerned. We have got three more small items to be done. Allocation of capital. A company can increase, consolidate or divide its capital under section 61. But you cannot have a consolidation if it is going to change the voting percentage unless approved by a tribunal. Consolidation is subject to control. But consolidation or conversion can be done only in respect of fully paid up shares. And even when you do subdivision, the proportionate rights shall remain unaffected. And alteration also includes cancellation. If the company has lost money in terms of accumulated losses, to that extent it can cancel the shares, and that is called cancellation shares, and it will not be considered as a reduction of capital, but the process has to be followed. Increase, consolidation and divide, it should be fully paid, and the pro rata relation has to remain. And rights, if there is any change in the rights and voting percentage approved by the tribunal, and cancellation or diminish the amount of capital can also be worked out, and it shall not be attracting the provisions of reduction of capital, but notice has to be given to the registrar for alteration. Reduction of share capital is a process. It requires special resolution to reduce the liability on any share capital not paid up, because it affects the creditors and other lenders. Confirmation of tribunal is required. It is used for cancelling the lost capital or paying off the excess. And it involves altering the memorandum for reducing the amount of share capital and its shares accordingly. But once again, to reduce capital, the company has to have sound financials. There should be no arrears of repayment of deposits or payment of interest. The tribunal, when it is applied for, will give notice to SEBI, will give notice to creditors, and a period of 3 months is given for them to respond. If no representation is received, the tribunal presumes no objection and proceeds ahead. The tribunal satisfied only when it is convinced that every creditor has been discharged or his consent is obtained, then only it will confirm the reduction of capital. And the tribunal always insists that any reduction in capital has to be in conformity with the accounting standards. A certificate to that effect from the company's auditor has to be filed with the tribunal. The order of confirmation issued by the tribunal will be published by the company in such manner as the tribunal may direct, and a certified copy of the tribunal order indicating the amount of capital, number of shares, amount of each share, amount of date of registration deemed to be paid upon the share is filed with the registrar within 30 days. And the registrar will issue a certificate to that effect. With that, the reduction of capital is presumed to be completed. And this reduction should not be used for buyback of shares, and no reduction should compel a person to contribute more than what he would have contributed in the normal course. Means it should not be to the disadvantage of any shareholder. And if in the list submitted to the tribunal, if any creditor's name is missed out intentionally or otherwise, the creditor can approach the tribunal and tribunal can pass orders making every member responsible to contribute to settle that creditor as if it is a settlement in the course of winding up, and they end up as contributories and the tribunal's orders will be binding on them. And there are offences listed in terms of concealment, misrepresentation, which will attract section 447, which deals with the fraud and criminal punishments in that regard. And there is a minimum penalty also for offences which are punishable. Buyback of shares. A company can buy back its own shares by making use of free reserve security premium and proceeds of the issue of any shares. We cannot use proceeds of an earlier issue to buy back now because it will be revolving in a endless cycle. The buyback has to be authorized by article and there should be a special resolution passed. The buyback could be not more than 10% of the capital and free reserves, and it should be authorized by the board by means of a resolution passed at its meeting. In a financial year, it could not exceed 25%, and the debt equity ratio should not be more than 2. The central government may notify a higher ratio. Requirement is all shares should be fully paid up, and it should be in compliance with the SEBI regulations. Between once a buyback issue is closed, for the next 1 year, there should be no further buyback. Means a gap of 1 year has to be there between one closure and opening of another buyback offer. And explanatory statement has to have the full details of the class of shares, amount to be invested, time limit of completion, etc. Every buyback has to be completed in 1 year from the date of passing the resolution. The buyback may be from existing shareholders or from the open market. It could also involve shares sold to employees under stock option scheme. And the special resolution has to be filed with the registrar before proceeding with the buyback. And in case of buyback, a declaration of solvency signed by at least 2 directors, verified by affidavit that the company is capable of meeting liabilities, and it shall not be rendered insolvent within a period of 1 year from the date of declaration. The declaration of solvency will be filed with SEBI, and where a company buys back the shares, the next step will be it has to extinguish and physically destroy the shares as last step in the process. And once a share has bought back and cancelled, it cannot make a further issue of the same shares within a period of 6 months, except for conversion of warrants or stock option schemes or sweat equity. Company after buyback will file the particulars of buyback with the registrar of companies. For any default, there are penalties to the company as well as the officer in default. Last point is regarding in certain circumstances company cannot buy back. A company cannot buy back through its subsidiary, through an investment company, and a company cannot buy back when it is in default of deposit payment or interest or redemption of debentures or dividend or term loan defaults. But if the default is remedied, it can have buyback after 3 years from the time of default. And there should be no default from the company in respect of annual return, declaration of dividend, distribution of dividend, and financial statements. Thank you so much.